is case 13-1255. And Mr. Ghanem, I understand you're representing yourself on this one?
Yes, sir, that's good.
All right.
I approach the bench.
The podium, yes, sir.
Yes, sir. Or the podium, you not the bench.
Did you want to save any time for rebuttal, sir?
I would like to have 5 minutes, Your Honor.
All right. And then this is your opportunity to tell us about just the issues in this particular case, not the previous case. So,
absolutely. That's what I would like to do, Your Honor.
all right. Very good. Please proceed, sir.
Gentlemen, I would like to express my deepest and most sincere appreciation of the court for giving me the opportunity to present my case at oral arguments. Thank you. I present to you first and foremost that no one, absolutely no one, can follow orders like a U.S. Marine. Gentlemen, I am a U.S. Marine. I know how to follow orders, and I know how to obey the rules. This appeal, 1255, consists of 2 issues. The first issue is an appeal of an order holding me in contempt of court for failing to obey and follow a court order, specifically the final judgment order in the divorce case. The contempt order basically grants the former wife's motion to enforce the final judgment and to find me in contempt. This order, which holds me in contempt for not following the final judgment, is erroneous and faulty and must be reversed. The final judgment order entered by Judge Robert W. Hodges specifically states that the house next door to the marital home, located 2122 Southeast 3rd Place, Ocala, Florida, will be split evenly between the parties. Within 30 days of rendition of this order, the home shall be placed up for sale, and the proceeds of the sale will be evenly split between the parties. The husband will determine the sale price listing for the house based on a recent appraisal of the home's value. And I repeat that, the last paragraph. The husband will determine the sale price listing for the house based on a recent appraisal of the home's value. The final judgment order is silent as to the other specifics or issues concerning the sale of this property. That's the only thing that they mention. When the house in question was first purchased, it was originally titled in both parties' names. In approximately 2001-2002, we separated, myself and the former wife, as a result of her illegal activities committed during our business that we had together, which was a clinical research business. That forced us to close the business. By the FDA sent an order out for us to close the business, and also we forfeited the business due to court action and to the FDA and the federal government. So we lost a total of $1 million business and a $350,000 medical building. During that time, we had separated. We agreed on a verbal separation. So what I did is I purchased and paid her off for all her interests in this specific house. There is a check that I gave her that is included in the record. It's page number 351 of the record on appeal, if you'd like to take a look at it. And you'll see her signature on the page. Oh, I'm sorry, on the page and on the back of the check. In the trial, the former wife did not object to the introduction of this evidence at trial, and she testified and acknowledged that she received and cashed this check and kept the money, and that this money is for all interests in this house. It says right on the check, for all interests in this house. At the same time, the wife signed a deed transferring title back to me for the payment that I gave her. A copy of this deed is also entered into evidence in the trial. It's page number 353 and 354 of the record on this appeal. The trial court declined to consider our separation agreement, as you all heard, and failed to take into account the exchange of property and assets between myself and the former wife. The court erroneously determined that the house is a marital asset in order that it be sold and the sale proceeds be divided evenly between the parties. The former wife's second motion for enforcement of the final judgment, entered October 24, 2012, and for contempt, seeks enforcement of certain provisions of the final judgment. Specifically, requests for an order, and right on the order, the first paragraph says, to compel me, the former husband, to list the 3rd Place home for sale based on a recent appraisal of the home's value. The second paragraph, to find me, the former husband, in contempt as a result of his willful and reckless disregard for this court's final judgment. Prior to the former wife's motion, I followed precisely the provisions of the final judgment concerning appraising, listing, and selling the house in question, 2122 Southeast 3rd Place house. I obtained an appraisal from a certified and state-licensed appraiser and listed the house for sale with a state-certified licensed realtor on the open market. And the realtor listed it on the MLS, which is a multiple listing service that real estate agents use. The listing price for the house was $55,000, which was exactly and was totally based on the value that the appraisal came back with. The appraiser valued it at $55,000. I listed the home for $55,000. To validate the market value of the house at $55,000, as indicated on the original appraisal, I obtained a second appraiser from a totally different and totally independent appraiser. The second appraiser valued the house at $53,000. And normally within the appraisal business, if you're within 10% of the appraisals, that's good. So it is within the 10% margin. So one's $55,000, which I listed the house for. The second one was $53,000. I also obtained 2 market analysis from 2 different real estate agents. First, Mrs. Carolyn Torrey, who's the president of Fort King Realty. She valued the house at $58,000. The second realtor is a broker who's a senior broker at Coldwell Banker. She valued the house at about $55,000 to $57,000. So all 4 people who are licensed and certified in the state of Florida to give values on homes indicated the value of the house is about $55,000. Shortly after listing the house on the MLS, an offer was made by the buyer for the exact amount of the listing price. I had no choice but to accept that offer. I mean, the offer was for $55,000, the same exact price as the listing price, so legally and technically I couldn't say no. The former wife argues that the sale was improper because the buyer is a friend. This argument is faulty. The sale was not a closed sale, but to a friend. I mean, I didn't go out there and I sold that house to the friend. I listed that house on the open market with a realtor. Anybody in the world could have bought that house. I didn't go out behind everybody's back and try to sell that house. And when I did list it for sale, I used the value that was given to me by the certified appraiser. So I was confident that I followed the final judgment. And I know that they're arguing that the individual is a friend. Unfortunately, Ocala is a very small town, and I'm in the real estate business, and I know most of the people in the real estate business. So I have a lot of friends that I do business with. And that has nothing, that's not an issue. The issue is whether the appraisal was proper or not. Both appraisers are appraisers that I chose, that I've never done business with, don't know, never dealt with before. I picked them out of the phone book. I just picked up the phone book, called a whole bunch of people, and the first one that responded, Mr. Charles Rickle, he was a state certified appraiser, had a big ad. He says, I can do it. I can do it the soonest. I had other individuals bid on it, but he's the soonest. So I picked him. I contracted with him. I did absolutely nothing wrong, and I did not violate the final judgment. On the contrary, I was in full compliance with the provisions of the final judgment concerning this matter. The trial court should have denied the former wife's motion as being moot. During the hearing on the motion, the court declined to accept into evidence my appraisals. The court also declined to allow me to bring the appraisers and hear them as witnesses. I had the real estate brokers. Both of them were there. The buyer was there. Everybody was there to testify to prove that this is a legitimate sale. But the court declined and refused to allow me the opportunity to present witnesses. On an Oratinas motion by the former wife during the hearing, the court ordered that I am prohibited from selling the house. The court's order provided that the former wife shall obtain an appraisal of the house, and if I am in agreement with the former wife's appraisal, I shall list the house for the amount of the highest appraised value. If there is a dispute as to the fair market value of the house, the sale shall not take place until further court hearing. That's what the court said. By this court order, by the court order that we're talking about, the court has technically modified the terms of the final judgment. First and foremost, I have already determined the listing price of the house based on a recent appraisal, and I have already entered into a valid listing contract and sales contract based on the exact value of the appraisal. There's no reason to find me in contempt. I followed the exact provisions of the final judgment. Now, if I didn't follow through with the sales contract, if I didn't get an appraisal, then I can see the court find me in contempt. But in this case, I followed the exact provisions of the final judgment. Any court order interfering with my determination as former husband of the sale price listing and the pending sale of the house should be considered as modification of the final judgment, where it is specifically stated that the former husband shall determine the sale price listing of the house. The court's current order indicating that the sale of the house shall not proceed has denied me from determining the listing price of the house and is a modification of the final judgment order. Rule 1.530 of the Florida Rules of Civil Procedures contains a 10-day limitation from the date of the judgment and the date it is rendered to move for a hearing or to amend or alter the judgment. If a motion is not served and the court has not otherwise acted sua sponte during this 10-day period to include the requisite findings, the trial court is barred by rule from taking action. The same is true if the court has already denied a hearing and the 10-day period later expires. This is clear in Levy versus Levy, a decision that this court entered in 2005. The former wife's oratorious motion was brought in front of a court long past the 10-day window of opportunity to request modification of the final judgment. As such, the court's order is in violation of the rules and should be overturned and reversed. The second issue on appeal here is an order denying the husband's third motion to disqualify, an order granting recusal on the court's own motion. Since being assigned to the case in January 2011, Judge Robert W. Hodges has exhibited a tremendous amount of prejudice against me and complete bias for the former wife. A prime example is in the final judgment order. Here, he declined to consider a post-marital separation agreement. He indicated in the judgment that I never mentioned this agreement until the eve of the trial, which is malarkey, because I went in front of the judge and I told him, Your Honor, that was a year before. I says, Your Honor, she stole, I was in California when this whole thing took place, when she filed for divorce. I couldn't come back to my home. She broke into all my records and stole the post-marital agreement that we had. And I told him specifically, and you can look at the record and see where it's at. It's the hearing on May 13th, 2011, and it's part of the record. I told him specifically that she stole the post-marital agreement. And the judge comes back in the final judgment and says, oh, he didn't mention the post-marital agreement. In addition to that, I mentioned the post-marital agreement several times before in my pretrial compliance statement 2 years before. Judge Hodges also went on to assign the greater bulk of the marital assets to the former wife, to include the two major and primary rental properties consisting of the Ashley Court Apartments and the Azalea Garden Apartments, which generate 98% of the rental income. The former wife was also assigned 97% of the money in the bank accounts. He gave her my cash money, which I had, and I testified I've had this since before the marriage. She testified specifically that it was not her money, and she had nothing to do with that money. But the judge countermanded that. He didn't listen to the testimony. He said, no, this money is marital, I'm giving you half. Now, that's contrary to the evidence, contrary to testimony of the parties. Judge Hodges also failed to consider the loss of the medical building, which was forfeited to the feds due solely to the former wife's illegal activities. Now, the judge says in the final judgment order, the reason that you lost the medical building is because of the wife's illegal activities. But they both blame each other for it, so I'm not compensating the husband for it. He failed to consider any of the tax returns from 2003 to 2008, which indicate that I own 100% of the Azalea Garden Apartments. And that was in compensation for my loss of the medical building, or my part of the medical building. He also assigned a debt of $300,000 loan from my uncle, which I obtained, and there's wire transfers, documents, and bank account records, not only my promissory note, that shows that that money came into my accounts from my uncle, was spent on Ashley Court Apartments. And that's completely wrong. To me, that's completely prejudice. In this specific issue on appeal, the court delayed the hearing on my motion because we had three motions set for that date, 2 motions for the wife, my motion. My motion was set for hearing on that date in February 2013, 1 month before both wife's motions. And that motion was to get my documents and property back from the Azalea Garden Apartments, which the wife took over the same day, the next day after the final judgment came out. The motions were set for hearing, and in addition to hearing the former wife's motions first, he heard 3 additional motions of the former wife that weren't even set for hearing. The attorney for the former wife filed them the day before. I didn't even get copies of them. I mean...
Mr. Ghanem, I want to let
Yes,
you know
sir.
you're into your rebuttal time now. You can continue, or
Okay.
you can save the rest of your time if you wish.
I'll make it real quick, Your Honor. I'll continue, if it's okay. After the hearing, judge said we don't have more time to hear your motion. Go ahead and reschedule. I attempted calling. I did call the JA several times, and she never responded back to me. I left messages. Please call me back. This is Mr. Ghanem. I'd like to reschedule. I also went to the judge's. I wrote a letter since she never called me back. I took it to the judge's office. I had it delivered. I delivered it personally to the judge's office, and the signature sheets. Anytime you deliver something to the judge's office, there's a signature sheet of delivery sheets. It shows in there, and it's part of the record in this appeal. It shows where I actually delivered the request for hearing dates. Not once, but twice. And the judge, in his order, indicates that I never contacted him. Now, I mean, he's lying. I don't understand that, because I went up there, I called the JA, I personally delivered it. And I had to get those documents and sign-in sheets by a request, open records request, public records request to the Marion County people that take care of the building. So I got them, I filed them in the court, and it shows that I did go up there. I did send the judge. The judge was lying in his order. I did contact them, or attempted to contact them to try to get a hearing redone. The motion was legally sufficient. The motion that I filed to recuse the judge was legally sufficient and was in full compliance with Florida Statutes 38.1 and Florida Rules of Administrative Procedure 23.30. The statutes and rules indicate that in the order for the motion to disqualify, I have to show fear. I did show fear. The judge did not hear my motion that was scheduled for hearing. Plus, he refused to reschedule my motion. I had no choice but to file this appeal. I have absolutely no choice. I had to file the appeal. The other issue that I've got, Your Honor, is the one additional issue that I've got in additional motions. They filed, the former wife's attorneys and the former wife, the appellees, filed a motion for appellate attorney's fees. I do understand that the court can award attorney's fees by the rules, but the rules also provide that it should be based on the party's ability to pay these fees. I urge the court to look at the chart, which is Exhibit A, which I included in my response to the motion for attorney's fees, which shows specifically what the final judgment is signed. And it goes item by item. And it shows that I received $82,330. The wife received $2,091,791. That is a travesty, Your Honor. Right now, the only thing I've got coming in is my military disability payment, and I don't even have enough money from month to month to continue. I have to borrow money every month to do that. Thank you.
All right, sir. Mr. Bogdanoff?
Thank you, Your Honor. There are only 2 issues raised in this particular appeal. The first issue relates to, as partially framed by the appellant in his brief, is whether the trial court had jurisdiction to enter the enforcement order, and related to that is whether the court abused its discretion, since it did have jurisdiction, whether the court abused its discretion in entering the order, which it did not. And then the second issue relates to the motion to disqualify. I'll address the second issue first because I think it can be disposed of quickly. The former husband's motion to disqualify was denied, but on the same day the former husband received the relief he sought when the judge sua sponte recused himself. So the former husband did receive the relief he requested. Furthermore, the trial judge made the ruling in this case on the enforcement order on the record at the conclusion of the hearing on the motion for contempt and to enforce. He made his oral ruling. It was memorialized a few days after the motion to disqualify was filed, but under the decisional law that we cite in our answer brief, that's permissible, so long as the court simply memorializes a ruling that the court already made on the record. That's not inappropriate, and the court can do that. And that's what happened in this case. So there's no harmful error in connection with the motion to disqualify. The former husband received the relief he sought. Even though the judge denied his motion, the judge sua sponte granted the relief that the former husband sought. The first issue, I'll argue it in the other format. Did the court have jurisdiction? The answer is yes. The court not only reserved jurisdiction in its final judgment to enforce, but under the rules of civil procedure and case law, the court has jurisdiction to enforce its orders. In this case, there was a hearing conducted. The trial judge heard evidence that this piece of property that the court ordered in the final judgment to be sold and the proceeds split evenly between the parties, this piece of property was valued at trial, stipulation of the parties, at $130,000. Less than 2 years later, the former husband is attempting to sell this piece of property for $55,000. The trial court heard evidence that that was not the fair market value of the property, and therefore the trial judge found that there were certain red flags, as he stated, that indicated this may not be a fair market value sale. The other red flag, or other evidence that would relate to that red flag finding, is that the former husband received a contract on the property within 24 hours of placing it up for sale, and the contract was with a friend of his. So what the judge did was the judge held up the sale and said, I'm going to give the former wife 2 weeks to get her own appraisal on this piece of property. Then the parties can either list it for the higher of the two appraisals, or they can come back to court. So the effect of the court's order and enforcement was simply to stay the effect or the attempted sale of the property until these red flags that the court identified and which were supported by the evidence, until the court could determine, if necessary, how to proceed further. So there was no error in connection with the court's determination that there was substantial competent evidence that the sale should not go through. There was no substantive alteration in the final judgment. Each party still receives 1/2 of the proceeds of this property. So the former husband's claim that the trial judge somehow altered the terms substantively of the final judgment is in error. The only thing the court did was, realizing that there was real potential based on the evidence the court heard that this property was not going to be sold for fair market value, it adjusted the procedure that it had imposed and ordered another appraisal of the property. So the court was actually effectuating the terms of the final judgment, making sure that this property indeed sold for its fair market value and that there was not some chicanery, which, based on the evidence the court heard, there were strong indications that this was inappropriate and the fair market value was not going to be achieved. So that's all the court did. No substantive alteration. Each party still receives 50% of the sale proceeds of the property.
Was there a finding of contempt?
There was a finding of contempt, but there was no, the only remedy the court imposed was that the former wife have the opportunity to get a second appraisal within 2 weeks. There was no penalty or any punishment imposed on the former husband. The only thing the court did was held up the sale that the former husband had entered into, contracted with this friend of his. So there was no punitive action taken. It was simply the sale being held up for several weeks until the former wife could obtain her appraisal on the property. So that's all that occurred. There was no error committed by the judge. He had jurisdiction to do what he did. Everything else you heard related to the issues in the previous case, which we've already discussed and is not appropriate to be argued in connection with this case. There are just two issues here, and on both these issues there's no reversible error.
All right, thank you, sir.
Thank you.
Mr. Ghanem, you've got about 90 seconds left, sir.
Thank you. I just want to point out to the court that I contracted the realtor, Ms. Carolyn Torrey, 2 months before I received the appraisal. The reason I couldn't get an appraisal is because the wife, the date I went back to the house to try to sell it, the wife calls up the police, says, I'm trying to kill her, I'm armed, I'm dangerous. We have 5 police cars, 10 police officers show up. They search me. My arm is broken. I have no weapons. I'm with Mrs. Carolyn Torrey, the broker. I'm with a handyman. I can't even drive. The handyman has to drive me. We went to court. It took a month and a half to go to court. We went to court, and the judge found that all the wife's accusations were inaccurate. And he took the injunction away. So that's what took time. During the meantime, I signed a contract, and it's part of the record, with the real estate agent to show the house and actually to receive basically bids on the house, because I didn't have an appraisal value. I couldn't tell them. I says, get me bids, and then as soon as we get the appraisal value, I'll tell you what it is, and they can, if we got a bid above it, then we'll accept it. If it's not, then tell them this is what the value is, and you can do it. The day I got the appraisal, I took a copy and gave it to Mrs. Torrey. I had 10 people waiting to buy that house. One of the people that was interested in buying the house saw the price, which was $55,000, which is exactly what the appraisal said. And that person the next day put an offer for $55,000. It's not my fault, Your Honor. The house has been for sale for 2 months. We just didn't have a price on it.
All right, Mr. Ghanem, you've exhausted your time, and you need to wrap up.
Do I have like 30 seconds? Or the only other thing I want to say, Your Honor, is the appellees agree with me. They stated in their answer brief that the judge did change the final judgment. He tweaked it. He changed it a little bit. Changing is changing. Whether he changed it a lot or he changed it a little bit, he's not supposed to change it.
All right, that will conclude our docket for today. And